People versus Castillo.
Good afternoon. May it please the court. Matthew Bova for Mr. Castillo. I would request 2 minutes for rebuttal, please.
Yep.
There was a reasonable view of justification here, and that instruction should have been provided to the jury so the jury could resolve the classic questions of fact presented by the justification defense here. The decedent stood inside a barbershop blocking the door, told everyone inside that no one could leave, then turned to Mr. Castillo, who was just a few feet away, told him that he was not getting out of here, placed a razor blade up to his face, touching his cheek, and said, "I'm going to cut you from ear to ear." In response, during a period of time that lasted no more than a few seconds, Mr. Castillo fired 6 shots in self-defense. On those facts, a reasonable jury could have found that Mr. Castillo was responding to the threat of imminent and deadly physical force. Justification did not fade away because of a split-second spin after the first 2 shots. The question is whether a reasonable juror could have found that a sensible person in Mr. Castillo's shoes would have interpreted that spin as something other than the all-out abandonment of the attack that the appellate division envisioned. And here, there was more than a reasonable view that would justify such an interpretation of this quick split-second spin. The decedent had just been shot in the left chest and spun. Any reasonable person would have interpreted that spin as simply the result of the force of the bullets to the left chest, not as all-out abandonment. It is certainly true that—
So what was the threat that Mr. Castillo faced at the moment he fired the first shot?
It was the threat of the razor blade that was placed to his face and the explicit threat.
Okay, let's back up. Was the razor blade on his face at that moment?
At the precise moment of the first shot, no.
He had stepped back.
Yes.
So the threat he was facing was someone armed with a 1.5-inch razor blade?
Yes.
Who was a couple of feet away from him?
Yes.
And not armed with a gun?
He was not armed, but he threatened deadly—
He was armed with a razor blade.
Yes, not armed with a gun, but he was armed with a razor blade. And it's not only about being armed. What makes this case unique, too, is the explicit threat that he lodges. He tells Mr. Castillo, "You're not getting out of here. I'm going to cut you from ear to ear." That is the same thing, and any reasonable person would have interpreted that statement as, this person is going to kill me. And he's very committed to it. And the fact that Mr. Castillo is able to take one step back prior to exercising self-defense doesn't take this issue away from the jury, because at that moment, LeBron is readily capable of carrying out his deadly attack. So the first 2 shots, there was a question of fact for the jury that should have gone to the jury. The post-spin shots, those 2, there was a reasonable view that the threat continued because a spin does not indicate abandonment, or at least a reasonable person could so find.
There would be a point, counsel, when it would, right? So if he staggered out into the other room and the person followed them through and shot them in the back of the head while they were on the floor, that you would concede would not get you a reasonable view of the evidence, right?
Yes. I mean, if the decedent had left the salon, that would also likely nullify a reasonable view, because at that point, the threat is no longer imminent. But here, all we have—
4 to 5 seconds, right, I think is the testimony, that this takes place a few seconds.
Yes, and we know that from the video evidence also, because we could see people reacting to the shots, and then we see Mr. Castillo leaving within seconds of the shots. So yes, we have a split-second moment to react here. And the question—
Is there any evidence that he advances on him at all?
So he reaches across with his right hand, and
Right.
LeBron does, and then places— Yes.
But what does the record tell us about exactly how far apart they are, if it tells us anything?
Well, so the razor is placed to his cheek, then the testimony—
Is it placed on his cheek or just—
Yes.
I couldn't tell if it was placed near his face or on his cheek.
Yes, Garcia's testimony indicates that it's touching the cheek.
I see, okay.
And then—
I'm sorry, after LeBron does that, doesn't he step back away from LeBron?
Yes, Mr. Castillo takes one step back, according to Garcia's testimony, and fires the shots. But first of all, the fact that he's able to take a step back doesn't nullify the threat, because all LeBron has to do from just basically the distance from here to the end of the podium here, all he has to do is lunge at him.
How do we know
act on his
that?
threat.
I honestly can't tell from what I've read whether stepping back makes you 3 feet apart, 6 inches apart. I'm not sure. Is there a record site that you could provide to give us the sort of spatial understanding?
Well, the testimony, we know that he's right up to him because he places the razor blade to his face. Then the testimony from Garcia at A112 through 114 is that there's a step back, and then he fires the shot. So and LeBron, and also Garcia places LeBron right at the door at the time of this incident, and then also places Mr. Castillo right there as well. So we're dealing with a very...
We know that the muzzle of the gun is far enough away from LeBron that there's no stippling, right?
Yes.
And what does that tell us, if anything, about distance?
Well, according to the medical examiner's testimony, it's not that precise, but as the medical examiner testifies, it just indicates that they may have been more than 2 feet away. But that doesn't disprove self-defense as a matter of law. Perhaps the prosecution could make such an argument to the jury, but it doesn't disprove self-defense as a matter of law, because at that point, he's already threatened to kill him. He's already placed the razor to his face. Any reasonable person would say, this person is going to act on that threat. I need to use self-defense in order to protect myself.
Does he have a duty to retreat?
No, that issue is not only not preserved because the prosecution never said anything about it, but certainly there's no duty to retreat as a matter of law on these facts, because he's not readily capable of retreating with complete safety. LeBron is
How
blocking...
many, do we know how many feet are behind him till the end of the store? Not going the direction of the exit, the direction behind, where I believe there's another office. Do we know how big that store is?
I believe it's about 15 feet. But in any event, there's no indication whatsoever that Mr. Castillo even knew that there was a bathroom back there. But in any event, what it would be required here is that in order to retreat, he would have to have turned his back effectively to his assailant, banked everything on this hope that he could outrun the assailant to this bathroom that he doesn't even know about. So there's no ability here to retreat
I mean,
with
look,
complete
that's
safety.
your view, but there was a judge here who heard the witnesses and saw the exhibits presumably and listened to the medical examiner and made a determination the other way.
Well, the judge never made any determination about duty to retreat because the prosecution never argued it.
About giving the charge.
Oh, well, yes, and the judge ignored the legal standard. The standard is, viewing the evidence in light most favorable to Mr. Castillo, could a reasonable juror have found on these compelling facts, which the facts are coming from the prosecution's own witness, could a reasonable juror have found that Mr. Castillo was acting in response to the threat of deadly imminent physical force? And on these facts, that was amply established, and it should have gone to the jury.
Counsel, could you speak to, if we were to agree with you on justification, the effect on the possession count?
Yes, so the possession count would also have to be reversed, because the failure to charge justification infects the jury's assessment of intent to use unlawfully.
How so?
Because if Mr. Castillo's possession is with the intent to use the firearm lawfully in justification, then he's not guilty of that count. So but the issue of justification is never given to the jury, because the jury's never given the chance to consider justification.
It seems as if the charge here is also somewhat different, and I think that, if I'm correct, the jury was charged that they had to find that if the gun was used unlawfully in the shooting, to find possession with unlawful intent, which I think makes it more of an aggravator than it even would be under the standard charge. I think there's almost a mischarge in this case from the standard charge.
Well, the bottom line, though, is that because in this case, because there's no other evidence of an intent to use the firearm unlawfully under the prosecution, under the only thing that
for the presumption, right? There's no
Right.
presumption.
Yes, I mean, the only evidence that would support the theory of possession with intent to use unlawfully would be the jury finding that Mr. Castillo unlawfully discharged the firearm.
So if his use was justified and therefore lawful, there is no criminal possession?
Precisely, yes. So, and all the questions that we're having right now, all the discussion here, it should have gone to a jury. The prosecution could have stated its position in summation. Defense counsel could have stated its position in summation. The jury would have resolved these classic questions of fact. And here, the argument was not just reasonable, it was compelling. Because we're talking about someone who's dealing with a deadly predicament. Someone has just threatened his life. He has split seconds to react. His response was reasonable, but at least a rational, properly charged jury could have so found. Thank you.
Thank you.
Good afternoon. May it please the court. Cynthia Carlson for the people of the state of New York. The trial evidence showed that the imminent use of deadly physical force had ended by the time that the defendant fired his first shot. The evidence established that while the victim held a razor blade to the defendant's cheek,
So did he have to wait until he was cut?
he did not have to wait until he was cut, but he stepped back. That's
Does
key
it
here.
matter what transpired between, allegedly transpired between the victim of the shooting and the defendant earlier?
Yes, from the start of the confrontation, when the
But even before that, his returning, his insistence.
Oh, if the defendant knew about it, it could certainly go to the reasonableness of his response to the defendant.
But
And
here, is there any proof in the record that this defendant knew the circumstances before he went into the shop?
we know that there are phone calls made between the co-defendant who was interacting with the victim all day, and that within 6 minutes of the last phone call between the co-defendant and the defendant is showing up armed with a secreted gun, and then pulls it on the victim when he enters into, or after he enters into the shop. But importantly-
Just going to Judge Canataro's question before, is there anything in the record that shows how far they were apart when the defendant took the step back?
There is. There are a few indicators in the record. The initial part is the ME's testimony. The ME testifies that there's no stippling or fouling to the victim's body.
So that's 2 or 3 feet.
When asked, she says that it means it's greater than a few feet, not 2 feet, but greater than a few feet. And we're also talking about a razor blade that's not sheathed. It's 1 5/8 inches, and the force to be able to use a razor blade to cause death has to be so great that even 3 feet is significant. I would also note that on pages A131 to 132 of the transcript.
Let me just test that for a second. So I'm walking down the street, minding my own business, and somebody comes up to me with a razor blade of that size and says, "Give me your wallet or else," right? And it's 3 feet away from me. I happen to have a gun, and I shoot the person. No justification defense?
Not necessarily.
Well, suppose I can't retreat.
Not necessarily.
Okay, then why?
Because the distance between the victim and the defendant matters. And
So again,
Why
are
isn't
you
that a jury question?
it's not a jury question because the requirement that this court has set forth is that the threshold inquiry has to be made by the judge. There has to be a baseline. There has to be a limited
What about how
amount.
you're supposed to view the evidence in the light most favorable to the defendant?
But it has to be, yes, it's a light most favorable to the defendant, but it has to be a reasonable view. It can't be.
But what about the fact that the razor was placed up against him, and they're very close together at that point? Why isn't that the relevant reference point, not him backing up to pull out the gun?
Because the defendant stepped back.
I understand that, but
And-
why, in measuring the extent of danger to him, well, let me ask a different question. If the defendant had not stepped back and the razor blade was against his skin, would you need to give the charge then?
Then that charge could be given.
Would have to be given, would you say?
If the victim cannot step back, if the victim can't
Just
reasonably
saying
guess.
if.
Yes.
And so, then I take it that your view is by stepping back, the defendant deprives himself of a justification defense. Is that?
He doesn't deprive himself of the justification defense. Instead, he does what he's supposed to do for a justification defense. 3515 says that when you're faced with deadly physical force, you have a duty to retreat, and the defendant did it. He stepped back, we know, a couple of feet, greater than a couple of feet.
Well, wait,
By
why do we know he stepped back greater than a couple of feet?
A few reasons. The first is because the medical examiner says that when the-
Says a few feet, right? Whatever that
She
means.
says
2
greater
or
than a
3.
few feet, yes.
Okay.
And then what we also know is based on pages A131 to 132 of Denny Garcia's testimony, she is asked, she's shown the picture
Mm-hmm.
of the inside of the salon, and she's asked, where is the defendant and where is the victim in relation to the shooting? And what she says, and that photograph is on 1358 of the record, she says that the victim is to the left of a blue pillar by the orange cone, and she says that the defendant, I'm sorry, to the right
I mean,
of the
all
blue
of this
pillar.
suggests to me that these are points that you could well make to a jury and maybe you'd prevail. But why isn't it something that needs to go to the jury?
Because it rests on speculation otherwise. It doesn't go to the jury because the defendant hasn't established that at the moment he used
sorry.
the deadly physical force.
Before we get too far away from this, with respect to Jenny Garcia, my recollection is that her testimony was kind of all over the place, that there were some inconsistencies. Was she, what's the word I'm looking for? Was she consistent with respect to this distance description that you're talking about at A131 to 132?
She says, reading her testimony as a whole, as one would be required to do, she says that he's standing at the blue pole, the victim is, the victim is standing by the blue pillar. When asked in relation to the orange cones, she says next to the orange cone, and then
she never
says,
equivocates on this.
there's some confusion, I think, when she starts to compare it to other photographs that were entered into evidence. But her point was that the victim was still by the blue pillar by the entrance.
She had
and that the
originally,
defendant
she had originally said she wasn't in the room at all, right?
I'm sorry?
She had originally said she wasn't in the room at all when
That's
this
correct.
happened.
She did say that she initially wasn't there. But that, if she wasn't there, that wouldn't establish justification for the defendant, and he wouldn't be entitled to the charge.
Did the people preserve duty to retreat?
I'm sorry?
Did the people preserve their claim that he was required to retreat?
Yes. In the sense that the people opposed the justification defense. They didn't put forth why. They weren't specifically why justification wasn't appropriate. And the court said that having reviewed the testimony of the witnesses, the photographs that came into evidence.
Well, but don't you think it's fair that if you wanted the court to decide whether, given the circumstances, the layout, the pictures and so on, that it was feasible to retreat, you needed to say that?
No, because it's all part and parcel of the same argument of whether justification is appropriate. There are three reasons that justification has to, or three prongs to the test that justification has to be met, and the prosecutor was saying, we don't believe it was met at all. And so to go in and specifically say, well, it wasn't met because at the moment that he fired the weapon, the moment he fired the weapon, he wasn't facing deadly physical force as he is required to be facing. This court in Jones had noted, like, there's no reasonable belief
But this is all happening in a blink of an eye. This is not minutes. This is, yes, you can break it down now. We, of course, can all break it down now. But it's happening in a blink of an eye. You step back and you shoot. That strikes me as the kind of thing that goes to the jury, assessing the credibility of the witnesses, looking at the evidence, listening to the arguments, and deciding for itself. Yes, this man did or did not have a basis to fear for his life and was justified in that moment in pulling the trigger.
But New York State does not require that it has to be over minutes. We are not a stand your ground jurisdiction. Inherent in the historical tradition of justification is that there's a mindfulness.
It's got to be, it doesn't require it has to be 2 inches either. I mean, you're not saying anything with that. The
No, but
point,
what we're
you
saying-
do recognize that this is not like perhaps some other case where, yes, there's a pause, there's some time to reflect, or he has the opportunity safely to look and see if he can get away.
But he has to be mindful at the time that he's facing the deadly physical force. He has to be reasonable in his subjective belief that there is going to be
A
deadly
blade to
physical
the
force
cheek,
used
I'm going to
against him.
cut you ear to ear. You step back and pull the trigger.
He steps back.
It takes less time than what it took me to say that, by the way.
I'm sorry, to do what?
It takes less time than what it took me to say that for that to happen.
To step back?
Yeah.
Well, certainly, but the defendant is still
And
under an
shoot.
obligation to have a reasonable belief that he is facing deadly physical force, and he wasn't facing deadly physical force. It's a 1 5/8 inch loose razor
What
blade
would
that
have
has to
made
be
it?
held.
What would have made it reasonable? What would have made it?
A gun. If the victim had a gun in
So if
hand.
he had a gun,
Yes.
Ah, so it's not the distance between them. It's
It's
not whatever he threatened them with, it's the fact that it's a razor blade.
It's a combination of factors. One particular factor could be that the victim had a gun. If the victim has a gun, then the defendant would have been justified.
So do you disagree that if someone slices you at a particular place, let's say it slides from your face to your throat, that they could in fact cause you to bleed to death?
No. It certainly could be deadly physical force. At the time that that razor blade was held to the defendant's face, that could be deadly. That is deadly physical force. But the defendant stepped back and he did not get cut. The facts of this case matter. Justification is a fact-based
So is there any
intensive
evidence
query.
that when he stepped back, that the decedent kept approaching?
No, there is absolutely no evidence. Denny Garcia testified that the defendant stepped back and was asked, and then what happened? And she said that the defendant fired the gun. The defendant
What if
never
because it's
testified.
instantaneous or it's in a blink of an eye, there's no such time? There's no such time. You pull back and you shoot.
But no one testified that there's no such time for
And
him.
again, isn't that for the jury to parse out?
No, because there has to be a basis in the evidence to reasonably believe that the defendant faced deadly physical force for the court to then give the charge. The court isn't.
Do you agree that the amount of time that it takes for these events to unfold is a factor to be considered in a judge reaching their conclusion about whether or not it's reasonable?
You
agree?
Certainly, it could be a factor. It could be a factor, but here,
When is it not?
it depends on, in this case, it's not a factor, because the victim, at the time that he is facing the defendant, this deadly physical force, would have to be something more than a 1 5/8 inch razor blade. It is less than 2 inches, smaller than a paperclip.
But you're saying he needs a gun.
He would need a gun.
If he had
And
a hammer,
No.
if he had a bigger knife.
Potentially with a bigger knife, depending on the size of the knife.
Because?
I'm sorry?
Because? Why does that matter?
Because it's about, this court in Dot said that what creates deadly physical force, what defines deadly physical force, is the capacity to cause death. A small razor blade from a distance greater than a few feet cannot cause death. When it's against his face, against his jugular, sure. But we're talking about the ability to use deadly physical force is at the time that you're actually facing deadly physical force.
Counsel,
He was not facing
I'm sorry
it
to
then.
interrupt you, but could you address, if we were to disagree with you on the justification charge, what would the effect be on the possession count?
The possession count should still stay. The reason being, as this court noted in Pons, that justification is about the use of the weapon, but the criminal possession of the weapon charge is about the intent to use.
Clearly, Pons and Almovidor, I think is the other case, says you don't get a justification charge to a possession count, and we've said that at least twice. The issue, I think, is the jury could have considered what is, the jury now could have found to be a lawful shooting as proof of the intent to use unlawfully. And in fact, I think on the instructions that were actually given in this case, they had to find that.
In order for the weapon charge or for the justification charge, for every shot to have been justified, that would then mean that the shots to the back, where the victim has completely turned around.
That's a justification issue, but let's say they get the justification charge, you had asked for every shot needs to be justified if it was given. They get those charges, and the jury still finds justified. 4 to 5 seconds, okay, all were justified. Now they could still find, without a proper instruction, that the intent to use the weapon unlawfully is based on that shooting, which with a properly instructed jury would have been lawful.
But it's also about the continuum of the defendant's activity with that gun. So it's not just the moment that he brandishes it in the salon. It's the moment leading up to it. We have the evidence that there are phone calls between the co-defendant and the defendant.
And it may well be a jury could find that, but I think there's some problems because, one, the way the jury was specifically charged in this case, but even without that, they could find that, but you wouldn't know if they based it on that or without the proper instruction, and there is one for when you get there is an instruction for when you get a justification charge, other than what is the lawful. discharge.
There is an expanded intent charge on a weapon, but the facts of this case don't establish
There's a charge
that
that
there's
says
not.
if you find the shooting justified, that's a lawful act, and you can't use a lawful act to prove intent to use the weapon unlawfully.
Right, but what Pons and Pons and its progeny talk about is it's not just that 1 minute. It's the continuum of
How
events.
do we know that's not what they used here, if they should have been instructed on justification?
Because it's so abundantly clear that the shots, the fatal shots, or not even the fatal shots, the one shot to the back that goes straight up his neck through his ear, it is so abundantly clear from that medical examiner's testimony, there is no way that the defendant the victim at that time was a threat, posed deadly physical force to the defendant, for the defendant to then be justified. I would also note, even if this court finds that the instruction should have been given, it's subject to harmless error analysis. And the uncontroverted testimony between Denny Garcia and the medical testimony, there is no way that these shots were justified. For that reason, the people would ask that the court affirm defendant's conviction.
Thank you.
Just as to the distance, the bathroom in the back, it's actually 35 feet. That's at A1354. So the argument here would have to be for the prosecution that they're making now for the first time, the unpreserved argument, which the court doesn't have to reach. But in any event, it fails on the merits because a reasonable jury could have absolutely found that he had no opportunity to retreat because A, there's absolutely no evidence whatsoever that he knows about this bathroom with these locks, and B, in order to get to that bathroom, he would have to bank his life on the hope that he can outrun a deadly armed assailant who's already threatened him to kill him with a razor blade. That's not the ability to retreat with complete safety, but like the other issues in this case, at a bare minimum, that's an issue that goes to the jury.
Can you address this argument that it's not, once he steps back, there's not really a threat from that kind of a razor blade?
Once he steps back, all we're talking about is a few feet. Even if we credit the medical examiner's testimony that because there's no stippling, it would have been more than a couple of feet, we're still talking about 3-4 feet at the most. That doesn't do anything to nullify the threat of imminent deadly physical force as a matter of law, which is what we're talking about here. We're not talking about whether or not Mr. Castillo gets dismissal. We're talking about whether a jury gets to decide this. And the jury...
I'm sorry for being obtuse, but is that because the victim can lunge at him with the razor blade? Is that what you're saying?
Absolutely, yes.
A few feet is not enough to make him feel safe.
No, because the person has just said, I'm gonna end your life effectively by cutting you from ear to ear with a razor blade. Merely being able to take one step back like this and going from the knife on the cheek to perhaps this far away does not nullify that threat as a matter of law. Okay. Because any sensible person in Mr. Castillo's shoes could have easily said to himself, I'm still in serious danger here because this person is committed. He's already put the knife to my cheek, and I'm going to die.
LeBron is blocking the door, right? That's his position when all this is going on. So I understand, and I'm not in any way trying to contradict your statement that he couldn't retreat, but in a 35-foot space, he took a step back. He could have taken a couple more steps back and completely obviated that legitimate concern about being assaulted with deadly physical force, couldn't he, or no?
No, not as a matter of law. That's not correct. Because what that's requiring someone to do is to hope and be optimistic. It's requiring someone to say this person's already.
I get it.
Sorry, Your Honor?
No. I understand what you're saying.
Because this person has already lodged a deadly threat. He's already shown that he means business because he's put that knife to his cheek. And to say, oh, now I'm okay because I've managed to get 4 feet back, it doesn't nullify the threat because any sensible person would say, this person's still going to charge at me. He clearly wants to kill me and he's already acted on it.
At least that's one reasonable view of it.
It is, and the jury should have been able to determine those issues.
Thank you.
Thank you.